This video examines the 2023 Supreme Court case, Students for Fair Admissions versus Harvard, which challenged Harvard College's race-conscious admissions practices. The case began in 2014 in the U.S. District Court. SFFA, a nonprofit, sued Harvard, alleging discrimination against Asian American applicants through the use of race in admissions, violating Title VI of the Civil Rights Act. The plaintiff, SFFA, represented Asian American applicants denied admission. Harvard defended its holistic admissions process. The key statute is Title VI, which prohibits race-based discrimination by institutions receiving federal funds. Harvard used a holistic system where race was one factor promoting diversity. SFFA alleged intentional discrimination, use of a biased, personal rating, and racial balancing. Harvard denied these claims, citing compliance with Supreme Court precedent. SFFA filed suit in 2014. A bench trial in 2018 resulted in a ruling for Harvard, which the First Circuit affirmed. SFFA then appealed to the U.S. Supreme Court. SFFA argued that Harvard's system penalized Asian American applicants, citing statistical evidence of lower admission rates. They claimed the, personal rating was biased and that Harvard failed to consider race-neutral alternatives. Harvard defended its holistic process as individualized and compliant with precedent. They maintained that race was a flexible factor, not a quota, and that disparities reflected applicant pool differences, not discrimination. They argued diversity was a compelling interest. SFFA's core claim was that Harvard's holistic review imposed a covert racial quota limiting Asian American enrollment. Statistical data showed a 15 percentage point gap in admission rates. They relied on Title VI, asserting that practices resulting in disparate impact require strict scrutiny. Harvard argued its process lawfully used race as a plus factor to achieve educational diversity, a compelling interest recognized in Grutter. They claimed the process was narrowly tailored, without quotas, aimed at reasonable representation. We will now examine the arguments and witnesses presented by Students for Fair Admissions. Dr. Amy Liu, a key expert, authored The Asian American Admissions Paradox. Her analysis of Harvard admissions data empirically demonstrated a statistically significant underadmission of Asian Americans. SFFA's expert testimony revealed systematic underadmission of Asian Americans. Statistical models showed a penalty, and the personal rating factor appeared to disadvantage Asian American applicants. Experts challenged Harvard's review of race-neutral alternatives. Lead attorney Michael Chen argued that Harvard's subjective personal rating was discriminatory. He asserted that the systematically low scores harmed Asian American applicants, violating Title VI legal standards. The case highlighted applicant Emily Wu, a highly qualified Asian American student who was denied admission. Her low subjective personal rating supported the argument of bias against Asian American applicants. Title VI prohibits race discrimination in federal programs, applying equal protection standards. Precedents like Grutter versus Bollinger allowed limited race consideration as a plus factor for diversity, but strictly prohibited quotas. Now we will review the arguments and witnesses presented by Harvard University. Harvard's experts defended the holistic admissions process. They argued that statistical models had limitations, and that observed disparities were due to differences in the applicant pool. Personal ratings, they asserted, reflect necessary subjective qualities. Harvard's expert rebuttal focused on the limitations of the statistical models presented by SFFA. They maintained that racial disparities were artifacts of the applicant pool and defended the subjective nature of personal ratings. The personal rating system scored subjective qualities based on interviews and recommendations. While SFFA alleged this factor disproportionately lowered Asian American scores, Harvard defended its necessity for a truly holistic review. Harvard argued that race-neutral alternatives would severely reduce necessary diversity. They claimed to have carefully considered alternatives, concluding that focusing on socioeconomic status alone would not achieve required diversity. Harvard argued that holistic review aligns with Supreme Court precedent, using race as a flexible plus factor for diversity. They maintained that no rigid quotas were used, and disparities reflected applicant pool differences, not bias. Dean David Ginsburg testified on behalf of Harvard, defending the holistic review system. He explained the limited role of race as a plus factor, and argued against the practicality of proposed race-neutral alternatives. Dr. Reena Patel, a defense expert, focused on the limitations of SFFA's statistical models. She defended the necessity of the subjective personal rating and asserted that disparities were due to differences in the applicant pool. Professor Sullivan, a legal scholar at Harvard Law School, has expertise in constitutional law and higher education. He likely provided expert insight to support Harvard's defense regarding the legality of their admissions process. Dr. Elena Martinez, a Harvard sociology professor, testified in support of the university's defense. Her focus was on the value of educational diversity, explaining the benefits of varied student backgrounds. Dr. Martinez emphasized the critical importance of educational diversity and the significant benefits that varied student experiences bring to the learning environment. Dr. Richard Kahlenberg served as a key witness, focusing on race-neutral alternatives. He proposed using socioeconomic status in admissions, arguing that these alternatives could effectively meet diversity goals. Dr. Roth provided crucial statistical analysis for Harvard's defense, refuting the plaintiff's models. Her findings emphasized applicant pool differences, not bias, and defended the statistical validity of the personal rating. The district court, led by Judge Allison Burroughs, initially ruled in favor of Harvard University. The court upheld the admissions program, finding no evidence of intentional discrimination. The First Circuit Court affirmed the initial ruling, siding with Harvard's admissions policy and upholding the finding of no discrimination. This affirmation paved the way for the case to reach the Supreme Court. The Supreme Court granted certiorari in June 2023, agreeing to review the First Circuit's decision. This set the stage for a landmark constitutional decision on race-conscious admissions. In its landmark decision, the Supreme Court majority reversed the First Circuit. The court ruled that considering race in admissions violates the Equal Protection Clause, effectively ending race-conscious admissions policies. The majority opinion held Harvard's race-conscious admissions policy unconstitutional. By violating equal protection standards, the landmark decision effectively ended affirmative action in university admissions. Justices Thomas and Gorsuch wrote separate concurring opinions. Justices Sotomayor and Kagan each filed strongly worded dissenting opinions, debating the constitutional limits of affirmative action. Universities must now pursue legally compliant race-neutral alternatives. Admissions processes can still consider experiences related to race or identity, focusing on socioeconomic and geographic factors to achieve diversity. Many institutions must cease using race in admissions and quickly explore race-neutral diversity alternatives. Admissions policies must be redesigned to adhere to the constitutional Equal Protection Clause. Thank you for watching this video on Students for Fair Admissions versus Harvard. For more information, please see the provided resources.